Client wants to make a statement to the court, Your Honor.
Sworn in, please.
Do you solemnly swear affirm the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
Situated, sir, if you'll please state your full name for the record and spell your last name.
Michael Zimmerman, Zimmerman.
I do think an inquiry is probably appropriate by the court just to clear up the issue that he is a criminal defendant facing a second-degree murder charge, Your Honor, and that anything he says, I want to make sure that he's aware of it, and so we're clear, I've discussed that with him.
George Michael Zimmerman.
And you had advised me that you wanted to make a short statement, is that correct? Correct.
I wanted to say I am sorry for the loss of your son. I did not know how old he was. I thought he was a little bit younger than I am, and I did not know if he was armed or not.
Nothing further, no.
And I'm sorry, sir, you're not really addressing that to the court. You're doing it here to the victim's family. Is that correct?
They are here in the court, yes.
I understand, but I thought you were going to address Your Honor, Judge Lester, not. So that's really addressed to the family and where the media happens to be, correct, Mr. Zimmerman?
No, to the mother and the father.
Okay. And tell me, after you committed this crime and you spoke to the police, did you ever make that statement to the police, sir? That you were sorry for what you'd done or they're lost?
No, sir.
You never stated that, did you?
I don't remember what I said. I believe I did say that.
You told that to the police?
In one of the statements, I said that I felt sorry for the family.
You did?
Yes, sir.
So that would be recorded because all those conversations were recorded, right?
Yes, sir.
Okay. And you're sure you said that?
I'm fairly certain.
Okay. And so which officer did you tell that to? And you gave 5 statements, I believe, total.
Yes, sir. I'm sorry. All the names blend together.
Okay. And do you remember if it was a male or a female
There were both males and females.
at the time you made that statement that you were sorry?
Yes, sir.
And let me make sure the record's clear. You stated exactly what to those detectives?
I don't remember exactly what verbatim.
Okay. But you're saying you expressed that concern for the loss of Mr. Martin, or that you had shot Mr. Martin, that you actually felt sorry for him?
I felt sorry that they lost their child, yes.
And so you told detectives that you wanted them to convey that to the parents?
I don't know if they were detectives or not.
Officers, I apologize.
I didn't know if they were going to convey it or not. I just made the statement.
Okay. And then you said that you called them up or you left a message for them to tell them that?
No, sir.
Why did you wait 50-something days to tell them, that is the parents?
I don't understand the question, I'm sorry.
Why did you wait so long to tell Mr. Martin and the victim's mother, the father and mother, why did you wait so long to tell them?
I was told not to communicate with them.
Okay, so even through your attorney, you didn't ask to do it right away? Your former attorneys or anything?
I did ask them to express that to them, and they said that they were going to.
But before you committed this crime on February 26th, you were arrested, or you were, I'm sorry, not arrested, you were questioned that day, right? February 26th.
That evening
That
and
evening,
into the
yes, sir.
27th.
And in the following morning, is that correct?
Yes, sir.
And in the following evening too?
Yes, sir.
Okay. Would you be fair to say you were questioned about 4 or 5 times?
I remember giving 3 statements, yes, sir.
And isn't it true that in some of those statements, when you were confronted about your inconsistencies, you started saying, I don't remember?
Outside the scope of direct examination, I would object, Your Honor.
Give them a little bit of leeway, not a whole lot, but a little bit here, okay?
Isn't it true that when you were questioned and you were questioned about the contradictions in your statements, that the police didn't believe it, you would say, I don't remember?
I'm going to grant his motion at this time.
Thank you, Your Honor.
Would you agree that you changed your story as it went along?
Absolutely not.
Okay. Now, sir, you had a phone when, at some point, and you agreed to turn over that phone to the police so they could make a copy of what was in there, right?
Yes, sir.
Okay. And in that phone, did you receive or send text messages, sir?
Yes, sir.
Okay. Did you ever make any reference to a reverend?
Object, Your Honor, outside the scope of direct.
Sustained.
Did you ever make any reference to Mr. Martin, the father of Mr.
Sustained.
of the victim?
I'm getting a little bit far away.
I apologize, Your Honor, my question is, he was asked in terms of apology to the family, and I'd like to be able to address that if I could.
I think you can classify it as whether or not he asked the apology. I don't want to get into other areas.
Yes, sir.
Thank you.
My question is, Mr. Zimmerman, do you recall sending a message or to someone, an email about referring to the victim's father?
No, sir, I don't.
And just to anticipate, I guess, is the court ruling that I can't ask him about his statements he made to the police in terms of his limited testimony. I just want to, before I get that, I don't want to be trying to ask the question, objections being made.
You've already anticipated, and you anticipate my ruling too.
Thank you very much, Your Honor.
Take a witness.
I have no further questions, Your Honor.
Thank you. Step down.
No further presentation.
State anything further?
No, sir, not witnesses.
Argument?
Yes, Your Honor. Though there is a presumption against bond initially with a felony like this, in order to maintain that, the state would have to convince you to a standard that I don't think they attempted to reach today, that being what we know commonly as the Arthur standard. I think then he is entitled to a bond. The question then becomes what conditions of release would be appropriate to do what bond is supposed to do, to assure his appearance back at trial. To that end, we do have some prior criminal record. We have, and you've heard the testimony, an event where it seems as though he may have been, in his mind, coming to the aid of a friend, led to his arrest for a couple of felonies, dropped down to misdemeanor. Pretrial diversion, as you know, and we all know, anger management is a condition of all pretrial diversions in those regard, not necessarily specific to my client, but he did successfully complete that. The injunction is in record. I almost invite you to review it because I think there's good information in there as to how he acted and failed to overreact with some of the events that happened. But what he did do was use the court system to get an injunction against her. They stayed away from each other, and nothing's happened since. And of course, there was no criminal event, even though she called 911 and suggested some type of a battery. So as far as his prior record, that's it, and I would suggest it is, in fact, as I mentioned earlier, minor. As far as his financial abilities, unfortunately, this is a family of very short means. You've heard mom and dad testify that they are willing to assist by securing their house. Whatever we can accomplish, we certainly will. I will tell you that I truly don't know the specifics of some fund that's out there that's not being administered by me. I don't know what the amount is, but when we look to the assets and financial picture of my client, we know, one, unfortunately, based upon these circumstances, he will not be able to work in public in the near future, so he cannot support himself. He has a wife who's not working presently because she's in school. I'm asking you to consider a reasonable bond, the amount of $15,000, that will secure his appearance, and there are other conditions. Certainly, with a case like this, I'm also going to ask you to allow Mrs. Zimmerman to leave the state. Further, I'm going to ask that you maintain an extraordinary level of confidentiality and secrecy over his whereabouts because of the potential danger that exists in this case. That can be accomplished by the use of a GPS monitoring device. I've been in touch with Seminole County. I would have brought them, but they would tell you information that I know you already know, which is that GPSs are nationwide now. They are secure. If we will know quickly if he is not in the location he is. We have surrendered his passport. He doesn't have a legal way to get out of the country, though there are always illegal ways, I suppose, for people to get out of the country. We then need to look at what Mr. Zimmerman has done during the time this event has been pending. As proffered by the state, my client stayed in constant contact with Florida Department of Law Enforcement letting them know exactly what was going on, and literally building a trust relationship with FDLE such that when they said to come in, though the active warrant wasn't identified, and I don't fault FDLE, they did exactly what they should do to secure the safety, he came in voluntarily and surrendered himself to law enforcement. He is well established in the community, 10 years, though he cannot stay in this community. He had a job that he was doing quite well at for a long time. He was able to support himself. And I must back up. You have no testimony concerning his employment, and I apologize. Can't be considered. But certainly, when we look at this case, I would suggest that Mr. Zimmerman's situation suggests a bond. And the inquiry concerning the probable cause affidavit was for that particular purpose. If the state is going to say to you that this is a second-degree murder case, because I say it is, and that is what they present to you as evidence of second-degree murder, then I would ask that you consider the anti-author argument, which is not only could the state not prove this case to the author standard, that proof is evident in presumption, great, but that as of today, you and I know now more about what happened or may not have happened that day, and I ask you to consider that in considering whether or not you'll allow a bond and then the amount of it.
Thank you, Mr. Mayor. Mr. DeLorean?